All right, hi again. Welcome back. Attorney Steve Vondran here. We are bringing you another exciting video from the world of BitTorrent litigation, P2P, peer-to-peer, file sharing. Okay, and here we go. This is general legal information only and not legal advice. I'll warn you in advance. This is some heavy legal jargon going on here. So if you're looking for something a little more relaxing, this is probably not going to be the video for you. However, if you are faced in the world of technology law like I am, faced in the world of torrent lawsuits with companies like Strike 3 Holdings LLC, Malibu Media LLC, companies that are monitoring the distribution of internet porn, this may be an important case for you, okay? Now, this case comes out of the Southern District of California. Once again, general legal information only and not legal advice, so don't rely on this. Cases vary, the courts vary, the cases coming down, the opinions are varying. But here's your case number if you want to check it out right up here. Again, Southern District, California. This is an order denying without prejudice plaintiff's ex parte application for leave to serve a third-party subpoena prior to a Rule 26 conference. Okay, now that's a lot of jargon there. We'll get to that in a second. This is Strike 3 Holdings again, prolific file of copyright infringement cases in the United States, along with Malibu Media. The two, if I was calling them the Oakland A's, I would call them the Bash Brothers. Remember them? Canseco and McGuire? That's what I would call them. Strike 3 Holdings versus John Doe, the anonymous defendant. Nobody knows who it is, but we know it's a subscriber with an assigned IP address. There you have the address. So, as you may know, what's going on is Strike 3 doesn't know the name and address of the alleged infringer. Now, just because somebody has a cable account does not make them an infringer. I think we all know that. There are many false positives, as I would say. Many cases are dismissed. So this, to me, this is my opinion. This is not a perfect science. So, however, they are seeking to get the name and address of the person who they believe may be the infringer. I don't know that there's any way that they can tell for sure, but they are sure trying to get these names. Many courts are giving them these names, allowing them to serve this subpoena under Rule 45. But in this case, the judge said, no, it doesn't meet the standards. We're not going to let you go get the name and address of some internet IP address subscriber. Okay, so we're going to take a look at this. And again, this is a very important case. It's going to highlight the importance of looking at your complaint, looking at the allegations. Are they conclusory? Looking at the affidavits that are filed to go along with this motion, the declarations. Are they adequate? Are they making concrete allegations about geolocation technology? Are they giving the courts the kind of certainty that they're looking for so that they can allow a subpoena to be served prior to this Rule 26 conference? Again, I told you this was going to be a mouthful. This is heavy hitting in the practice of law, folks, okay? Now, just by way of just quick background, in these cases, generally a complaint is filed, and because the plaintiff does not know the defendant, they will name them as John Doe. They will file a motion for early discovery. Many times these are granted. They're not always something that you're going to be able to fight. However, in this case, as you can see, the court on its own motion said, I'm not going to grant it. I'm not going to let you go do this subpoena, wait it out, or give me some better evidence, is essentially what they said. And that's what I mean by denying without prejudice, meaning if they can come back and do it with sufficiency, then the court may grant it. Well, guess what? In this case, they dismissed the case. Voluntary dismissal, okay? So these are things we're looking for in the world of copyright defense, torrent litigation. So let's go down and take a peek here. Before the courts, plaintiff's ex parte motion, as I mentioned, there's no briefs filed. It's ex parte, so it's just the plaintiff telling the court what should be done. But the plaintiff has certain burdens of proof here. So let's go down and take a look at that. Background. Plaintiff filed a complaint against defendant alleging a single cause of action for direct copyright infringement. Okay, that's what we're talking about in these cases. File sharing, the swarm file sharing of adult pornography videos, okay? In the complaint, plaintiff asserts ownership of copyrights for adult motion pictures that are distributed through adult websites and DVDs. And you see there in that doc number, they're referring to the allegations that they're making. Okay, the complaint alleges that the defendant is using BitTorrent protocol to download and distribute plaintiff's motion pictures to others on a grand scale. I've seen that in other complaints. So some people may say that's just boilerplate, but apparently the defendant is distributing on a grand scale. The complaint further alleges that defendant downloaded, copied, and distributed a complete copy of plaintiff's copyrighted movies without authorization. According to the complaint, defendant's infringement is continuous and ongoing, and the lawsuit is the only way to effectively prevent defendant from infringing the copyrights. Well, some people have told me, well, why don't they just give me a warning? And had I known this was wrong, I would have just stopped. And there's other ways to stop infringement. It's not the only one. At any rate, I'll save my commentary for another day, another court. The complaint explains that BitTorrent is a system designed to quickly distribute large files over the internet. Instead of downloading a file, such as a movie, from a single source, BitTorrent users are able to connect to the computers of other BitTorrent users in order to simultaneously download and upload pieces of the film from and to others. Pieces, that's your key word. To use BitTorrent to download a movie, the user has to obtain a torrent file for that movie from a torrent website. The torrent file contains instructions for identifying the internet addresses of other BitTorrent users who have the movie and for downloading the movie from those users. Once a user downloads all the pieces of the movie from the other BitTorrent users, the movie is automatically reassembled into its original form, ready for playing. So the pieces are distributed by the swarm, and when you get all the pieces, you press play and you can watch the movie. That is the allegations here. Now, some people wonder if there is enough being downloaded to actually constitute a movie. That's a question of proof if the case goes forward and can't be settled. Discussion. In every application, plaintiff seeks to serve limited immediate discovery on defendant's internet service provider. We talked about that, AT&T and or AT&T Uverse, so that plaintiff may learn the defendant's identity. See, they don't know their identity yet. Specifically, plaintiff seeks an order permitting it to serve a Rule 45 subpoena on AT&T Uverse to obtain the name and address of the account holder assigned to the internet protocol. This IP address that's at issue. This is the one they found to be downloading. Back up at the top here. Generally, discovery, this is what we talked about, is not permitted without a court order before the parties have conferred pursuant to Federal Rules of Civil Procedure 26F. Blah, blah, blah. In the Ninth Circuit, exceptions to requests for early discovery have generally been disfavored. So this is not favored to allow a party just to go out and do this. However, situations arise such as the present where the identity of alleged defendants will not be known prior to the filing of a complaint. In such circumstances, the plaintiff should be given an opportunity through discovery to identify the unknown defendants, unless it is clear that discovery would not uncover the identities or the complaint would be dismissed on other grounds. Well, this is one beef that I have. I guess I'm just going to lay out some of my beefs here in this video, but just because somebody's an IP subscriber, like an 80-year-old lady, doesn't mean they're the downloader, doesn't mean they're the direct infringer, doesn't mean they did any video sharing. There could be an unsecured Wi-Fi. It could be lots of different reasons. It could be a group home. We've seen that. Group homes. You don't know who it is. So I always argued, is this really going to uncover the identities? No, I don't think so. And nevertheless, let's proceed. Some limiting principles should apply to the determination of whether discovery to uncover the identity of a defendant is warranted. Such early discovery should be limited to ensure that this unusual procedure will only be employed in cases where plaintiff has in good faith exhausted traditional avenues for identifying a civil defendant pre-service and to prevent use of this method to harass or intimidate. That's what I'm talking about. So you get the IP address and you get the cable operator to give you the name and address, and now the little old lady has to deal with this. even though she may not even, probably is not the person. Okay. So you tell me, is this harassing, intimidating? You tell me. But when people call me, they are stressed out. I can promise you that. Okay. Even the ones that didn't do it, yes, some cases are dismissed. Yes, some people didn't do it. So forth and so on. First, the plaintiff. Now, here's burdens on the plaintiff, okay? They have to show the judge. There's no opposing counsel there at this stage. So they need to show the judge first. The plaintiff should identify the missing party with sufficient specificity such that the court can determine that the defendant is a real person or an entity who could be sued in federal court. That's one. Second, the plaintiff should identify all previous steps taken to locate the elusive defendant. What do you mean, elusive defendant? These aren't elusive. The old lady with a subscriber account, she's not hiding with a beard and a bag of money or anything. To ensure that plaintiff should identify all previous steps taken to locate the elusive defendant, to ensure that the plaintiff has made a good faith effort to identify and serve process on the defendant. I told you this was going to be a mouthful. Third, the plaintiff should establish to the court's satisfaction the plaintiff's suit against defendant could withstand a motion to dismiss. This is their burden. If they want to do early discovery, they need to establish. There's lots of grounds for motion to dismiss. Jurisdiction's one of them. Thus, plaintiff must make some showing that an act giving rise to civil liability actually occurred, and that discovery is aimed at revealing specific identifying features of the person or entity who committed the act. That's what I'm saying. You're not going to know for sure when you get that name and address. If it's Alice from Brady Bunch, it's probably not, it's probably the wrong address, so not the infringer, you know what I mean? So anyway, lastly, the plaintiff should file a request for discovery with the court, along with a statement of reasons justifying the specific discovery. They should give you those. And this is the court talking, don't forget. This is not me. This is the court talking. Along with, as well as an identification of a limited number of persons or entities on whom discovery process might be served, and for which there is a reasonable likelihood that discovery process will lead to identifying information about defendant that would make service of process possible. All right, I got to take a break. Give me a quick glass of water here. All right. Now here's the key. Identification of the defendant with sufficient specificity. In support of plaintiff's ex parte application, plaintiff submitted 3 relevant declarations. First, a declaration by Tobias Pfizer states he is employed by IPP International UGIPP, which provides the forensic investigation services to the copyright owners by tracking, monitor, and detecting copyright infringement over the internet. So they're the ones watching you torrent. According to Mr. Pfizer, IPP monitors the BitTorrent file distribution network for the presence of plaintiff's copyrighted works. Based on his review of forensic activity records and other forensic evidence, Mr. Pfizer states he was able to determine the IP address was used to distribute multiple pieces of plaintiff's copyrighted movies. Each of these pieces was recorded in a digital file that are identified by a cryptographic hash file. Software is then used to reassemble and analyze the digital files to confirm that the files download being distributed by defendant's IP address were pieces of plaintiff's copyrighted movies that were quote-unquote fully playable. It's kind of like Humpty Dumpty, putting all the pieces back together again. According to this stuff's all made up by me. This is, God, I'm giving you guys good stuff here. According to Mr. Pfizer's declaration, Exhibit A to the complaint lists digital files of plaintiff's copyrighted works that were infringed using the defendant's IP address. Second, there is another declaration by Susan Stalzer states she is the plaintiff's employee familiar with the copyrighted movies. She was charged with reviewing the digital files enumerated on Exhibit A that were collected by IPP during its forensic investigation to verify that the files did indeed contain plaintiff's copyrighted movies. Following this verification process, she used the American Registry for Internet Numbers, ARIN, to confirm that defendant's IP address was owned by AT&T Uverse at the times of the alleged infringements. So she's performing that role. Third, a declaration by Philip Pasquale States he's a high-tech advisor for a firm that specializes in network security, data breaches, and protection of secured information transmitted across networks. Mr. Pascali was retained by plaintiff to individually analyze and retain forensic evidence captured by IPP. He uses a program called Wireshark to review the contents of the digital files collected by IPP and was able to determine that a transaction with this IP address did exist. Based on his experience in other cases, Mr. Pascali also represents, remember every case is different, but he represents that AT&T Universe is the only entity that can correlate the IP address to its subscriber and identify defendant as the person assigned the IP address blank, blank, blank during the alleged time of the infringement. So he's going, we got to go get this subpoena. This is the ISP. We know that. The complaint also alleges that geolocation technology by MaxMind, Inc., an industry-leading provider of IP address intelligence and online fraud detection tools, was also used to determine defendant's IP address traced to a physical address in this district. We're talking the Southern District of California, remember? So, in this regard, the complaint also states as follows. In order to ensure the defendant's IP address accurately traced to this district, plaintiff inputted defendant's IP address into MaxMind's GeoIP database twice, not once, but twice. First, when it learned of the infringement, and I guess is that maybe the first file? I don't know. The first infringement, the first piece? I don't know. Just prior to filing the lawsuit. Okay. Some district courts in the Ninth Circuit have determined that a plaintiff identifies Doe with sufficient specificity by providing the unique IP address assigned to an individual defendant on the day of the alleged infringing conduct and by using geolocation technology to trace the IP address to a physical point of origin. There's a case that's cited where it's from San Diego. Court said Malibu Media, hey, just fine. That would be sufficient. And other cases that are cited therein. So there's a key case to look up if you're doing research. Here, without explanation, plaintiff did not submit a declaration supporting its assertion that geolocation technology was used to ensure that the subscriber of the subject IP address was located in this district during the time of the alleged infringement. So they weren't using a declaration that geolocation technology was used and traced them into the jurisdiction. Of course, based on this, the court's going to say, that may not survive a motion to dismiss based on jurisdiction and or venue, okay? And that was the problem here in this case. So there's some conversation about previous steps to take to identify the defendant. I'm not going to go into that. If you want to read that there, talks about that. But here's the key point. Ability to withstand a motion to dismiss. Under FRCP Rule 12B, that's your motion to dismiss. A case can be dismissed for lack of subject matter jurisdiction or a failure to state a claim upon which relief can be granted. Under the Copyright Act, plaintiff may not institute an action in federal court until registration of the copyright claim. We know that. That's a recent Supreme Court case, Fourth Estate case. If you remember that, I have a video on that. In order to state a viable claim for infringement, you got to allege ownership of valid copyright and a violation by the defendant. We know that. As applied herein, the complaint adequately alleges subject matter jurisdiction. Subject matter is the subject of the suit, federal question, copyrights under these sections. The complaint further alleges that plaintiff is either the registered owner or has pending registration applications for the adult motion pictures that defendant's IP address copied and distributed using the BitTorrent file distribution network without plaintiff's authorization. Thus, it is apparent that plaintiff's complaint could withstand a motion to dismiss for failure to state a claim. So the court's saying they could get through a motion to dismiss if that was the grounds. Under Federal Rule of Civil Procedure 12B, a complaint can also be dismissed for lack of personal jurisdiction. This is the key here. Over a defendant or for an improper venue. Has to be in the right court in the right setting. To overcome a defendant's motion to dismiss under 12B2 for lack of personal jurisdiction, a plaintiff need only make a prima facie showing, again, their burden, by presenting facts that, if true, would support a finding of personal jurisdiction over the defendant. Personal jurisdiction can be established over a person who resides in the forum state. In copyright infringement actions, venue is proper in the district in which the defendant resides or may be found. So keep in mind, the point here is they're trying to subpoena the address because they don't know the address. Based on the record before the court, plaintiff has not satisfied its burden to make a prima facie showing that the complaint is likely to survive a motion to dismiss for lack of personal jurisdiction and or improper venue. And here's the reasons. First, the complaint alleges that geolocation technology was used to trace the offending IP address to a location in this district. Second, the complaint alleges that the defendant resides here based on the results of geolocation technology. Third, the complaint asserts that a substantial part of the alleged copyright infringement occurred in this district, but the big kicker, however, plaintiff did not submit evidence to support these allegations. There's your kicker, evidence. As a result, this court cannot conclude plaintiff met its burden of making a prima facie case showing that the complaint would be able to survive a motion to dismiss. Are you following this? If you are a superstar. You are destined for legal greatness or greatness in life because you are really tracking the issue here. Without supporting evidence indicating the offending IP address was located within this district during the relevant time period, the court finds that it would not be appropriate to permit plaintiff to serve AT&T Inc. and or AT&T Uverse with a Rule 45 subpoena. So no subpoena today. No subpoena today. Conclusion, there you have it. Blah, blah, blah. Court's given them a chance to come up with that evidence. And again, the case was dismissed. So this is a really important case. It just highlights why you need to closely look at these complaints and the evidence being presented and make sure it's sufficient evidence. If not, I'm going to do another video on a potential way to attack this. But I'm going to do that in another video because, frankly, I am worn out, getting a little hungry, end of the day. And I hope this has been helpful. I hope it teaches you a little bit more about torrent litigation. We are a leader in torrent litigation. We have appeared in over 100 federal court cases. If you need an attorney who knows their stuff, do not trust this to your corporate counsel. Many times this is way over their heads. Or as I say sometimes, my buddy who's an attorney. Sometimes I get that. So anyway, you know where to find us if you need help. You've received a subpoena from your ISP, involved in a copyright infringement action, or need to bring a complaint under the copyright laws, DMCA, all that good stuff. You know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Thank you for listening. If you like this video, give me that thumbs up. It keeps me going. Better yet, subscribe. Help me get to my magic number of 15,000. I'm getting there. We're almost there. And if you like this video, it's helpful, don't be afraid. I don't mind if you share it on your social media networks. What other attorneys bringing you the information? attorneysteve.com. Thanks a lot for listening. Have a great evening.